Your Honours, it is so easy to choose as a target for prosecution a politician because of the way he presents his policies. If Rodrigo Duterte is to be faulted for anything, it is for his inappropriate choice of language. But he murdered no one. The prosecution speaks of thousands of victims in toto, data sets, patterns of violence. Now, the defense does not deny that much drug-related violence did occur. It was occurring before Mr. Duterte assumed the reins of power and continued, as we have shown, by way of a sharp increase after he left office. The defense firmly submits that the pre-trial chamber should not commit any one of the 49 incidents to trial unless it concludes that there are substantial grounds to believe that Mr. Duterte's criminal linkage and liability has been established for each one. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out, pulled the trigger, or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b). But the prosecution cannot show such a causal link. They've never been able to do that. There is no smoking gun in this case, and that is not for want of a desperate attempt to find one on the part of the prosecution. And if the prosecution seeks to displace that document and call the entire state apparatus into question, then the burden rests on it to produce credible, objective evidence rebutting that presumption. Bare allegations or reliance on single prosecution witnesses cannot suffice to overcome this presumption of authenticity and correctness, nor should the burden shift to the defense to prove that those documents are not falsified.